I'm here with our weekly reporter, Marc Z from Marc Z Legal Staffing, Longfellow Staffing, who is our personnel reporter, the three Ps of personnel. Welcome back, Marc.
Jeff, great to be here. Great to talk about some relevant subjects. And one relevant subject I want to talk about, which just took place on our election cycle on November 4th, was where Massachusetts voters approved a sick leave law. And that affects our audience of small and big businesses. And I thought I would talk about it this morning because it's something that our entrepreneurs have to have on their minds. 60% of the voters of Massachusetts approved a law that will require employers of 11 employees or more up to 40 hours of paid sick leave. But smaller businesses have to be included in that number too. They won't have to pay it, but they have to give it. So there's so many issues that that businesses have to consider because this is going to affect tardiness. This will affect productivity, and our businesses have to decide how this law applies. So, for example, does it apply for full-time, part-time, temporary, or seasonal employees? And that's what the Attorney General is going to have to interpret that law to, because from what I understand, this sick policy could affect all those areas, and bring a lot of issues to the workplace. You really have to look at your policies, what your sick leave is or your paid time off, because a lot of our entrepreneurs say, well, there's no problem. We already have a PTO, paid time off policy, so we're not affected. But you may be. It may not be generous enough. Or you may have a situation because how, quote, the sick leave policy applies, it may look at that employee that decides to go to a New England Patriots game and is hung over, and he says, you know what, let me use my 5 hours out of my 40 hours and come in late morning. You might not, as an employer, be able to let this person go because if he's got or she's got these sick leave, whether it's unpaid or paid, you may not be able to hit them up for tardiness if they've used all their sick time. The interesting part, not only to our entrepreneurs with full-time jobs, but this could apply, from what I understand, to part-time jobs and seasonal employees, temporary employees. So, for example, here's the issue: 11 employees, but where do you draw the line? So, if it's an under 11 company, you have to still give it, but you don't have to pay it. Okay, if it's 11 or over, what's going to happen is you have to pay it. And for like a company like mine that's in the temporary business, that makes it challenging because I have people on temp assignments for long periods of time sometimes. And so after a certain period of time, they technically could be an employee, and that's up to the Attorney General to interpret what is a person who's going to be eligible under these standards. It's something that our entrepreneurs should talk to an employment attorney on, have their policies looked at, and really cover themselves, because what they don't want to do is, once this law is implemented, be put in a position that they're on the defense and trying to be proactive. They have to look at their type of jobs, bringing their employment handbook or bringing the policies in line with the law, and also try to think strategically in terms of how it can work for them. Because what they don't want to do is, as I say, have somebody who takes advantage of the 40 hours. And if that person ends up being tardy and is using it as a way to extend their employment, that's not going to be effective either. So there's got to be a way to balance out.